So good morning, dear colleagues. Good morning, members of the public, and welcome to the candidate for the position of a judge at the Constitutional Court of Ukraine, Mr. Maksym Muzyka, a judge at the Khmelnytsky Oblast Commercial Court, who was admitted to the competitive selection by the Verkhovna Rada of Ukraine. The advisory group of experts gathered today in full composition to interview that candidate. Interview will be moderated by the advisory group of expert secretary, Mr. Yaroslav Romaniuk. That's why I'm giving the floor to him. Please, Yaroslav, the floor is yours.
Thank you, Mr. Chairman. Good morning, Mr. Maxim Vasilovich. Greetings, dear members of public. Mr. Maxim, today all 6 AG members are present here. Our chairman, Mr. Ales Zalar, who is present online. And physically we have here in this hall the AG members, Miss Hanna Sukhotska, Miss Maureen O'Connor, Miss Natalia Kuznetsova, Miss Oksana Vasilchenko. Other alternate AG members are also in attendance, namely Mr. Thomas Griffith, Mr. Richard Barrett, Mr. Marek Zubik, Mr. Vasil Shakun, and Mr. Volodymyr Kuzmenko. And myself, the AG Secretary Yaroslav Romaniuk. We have enough time to accumulate information and data about you. We know a lot about you, and thank you so much for your communication and answers to the question. You agreed to present answers to the questions that we posed to you about your candidacy. We have a lot of positive information, but there are also some issues that we would like to be clarified during today's interview. So today we give you an opportunity to clarify issues regarding your good moral character that will give you the possibility to explain yourself and your good moral values for the position of a judge of the Constitutional Court of Ukraine. I would like to drive your attention to the fact that, in accordance with the methodology, the candidate may not provide information, documents, or other materials during the interview if the advisory group requested their provision earlier and the candidate did not provide them within the specified period, or if the candidate could provide them on their own initiative earlier. However, the advisory group may make an exception if it determines that such an exception is justified. I would like also to inform you that the interview is being recorded and streamed live on the AG resources as well as the Constitutional Court of Ukraine website. Therefore, I call upon the AG members and the candidate to limit the use of sensitive data and limited access information on live air. So if there is a need, we will restrict the live streaming and we will stay in this hall to discuss such sensitive data. Dear candidate, I would also like to draw your attention to the fact that the duration of the interview is approximately 1 hour. I would ask you to be laconic, concise, and the time limit for the response to a question is 3 minutes. There are members of the AGE who are English-speaking, that's why, if you need, you can use the headset. You can use this headset, and the blue light would mean that there is Ukrainian channel switched on. Also, at the end of the interview, you make a short closing statement, up to 5 minutes. Now we're ready to start your interview. The rapporteurs on your candidacy are the AG members, Mr. Zalar and Ms. Kuznetsova. Please take the floor.
Yes, thank you, Secretary. If I may, I would start now. I would greet again the candidate. As you know, we try to clarify some open issues with you through exchange of written questions and your answers. There are still some issues which are not completely clear, and I will start with clarifying the source of funds you used when purchasing certain property. I will start with a movable property, in fact, with the car. In November 2011, you purchased a new Hyundai Santa Fe car. And the price of this car was 306,000 Ukrainian hryvnias, which amounts to approximately 38,000 US dollars. Now, according to declarations you submitted, your income at that period was only 115,000 Ukrainian hryvnias, of which 26,000 was income from independent professional business and 90,000 hryvnias from the sale of movable property. So, less of taxes, your available funds were 111,000 hryvnias, or approximately 14,000 US dollars. So you see, here is a discrepancy between the value of the car and your available income. How can you explain the purchase of a car which was 3 times worth more than your total annual income?
Good morning, dear experts of the AGE, Mr. Alish. Can you speak a bit louder, please? Or a bit closer to the microphone? Answering your question, I would like to say that Mr. Yaroslav Romaniuk said that I communicated with the secretary of the AGE, and also I provided information about this car. I provided documents that confirm this question, so I thought that this question is already clarified. But I would repeat now that part of these funds were mine, my income, and the other part was provided by my parents. I have already said about it in my written answers, and I even enclosed the documents that my parents had the income, equivalent income, from my father, from my mother and father also. And I provided tax information about my mother and the agreement of sale purchase about the alienation of the house in 2005 by my father. I wrote about it with both equivalents in Ukrainian hryvnias and in US dollars. I think that you have it in the materials of my dossier. So this is the answer to your question. If there is a need, you can find it out in the written answers and in the set of documents that I have sent to the secretary of the AGE. That is my answer.
Well, we couldn't figure out completely the source of this purchase, and that's why I'm asking this question. What was your parents' occupation at that time?
My mom was an entrepreneur, and she has been, and she still has business since 2003. I provided the copies of the documents and tax certificates with her incomes for that period. In that period, there was no electronic statements, everything was in paper, and there are statements and certificates from the tax service about her income. So now that's why it is strange here to hear this question today. Even I have these documents today. If you need, I can present them now.
The simplified taxation system is based on the accumulative principle. We have the data information about the income of your mother, which was in the year 2011, 361,000 Ukrainian hryvnias, and in the fact that your mother incurred expenses, excuse me, in the process of entrepreneurial activity, it's also taken into consideration, and this amount will even be lower. Besides that, your mother, of course, had some living expenses, personal expenses on a daily basis. So that's the problem here, because we cannot find an appropriate amount of savings, even on her side, to somehow justify your explanation what is the source of funds for purchasing this car. Nevertheless, let me remind you, in December 2011, your father also purchased a new 2011 Ford Kuga, and the price of that car was equivalent to between 30 and 40,000 US dollars at that time. And given this, the income of your parents' family in 2011 was insufficient to grant you such a loan. So how can you explain this?
Mr. Alish, thank you for your question, but now you said in the first part of your question about 361,000. It was not her income for the year, it was just for 1 quarter, so for a term. And I have also a document statement, it was the fourth quarter, 360, the third quarter it was 250, the third quarter will be 150, and the first quarter was 72,000. So these 361,000 Ukrainian hryvnias, it was only for 1 quarter, it wasn't for a year. I have a statement, I have already presented its statement, it should be enclosed to my dossier. This is about the income of my mother. Also, my parents had other income. I presented you the sale purchase agreement dated 2005. My father alienated a building and a land plot. And I stated that generally at that period it was more or less 30,000 US dollars. This is my answer.
We will take everything what you have said into consideration and make our own
Я попрошу звернути увагу.
I would ask you to drive your attention to the fact that I have submitted all these documents. It's not information from today. I have already sent these documents in advance to the secretary of the AGE. I sent it in February or in January, I don't remember when there was communication. And when I came to the Constitutional Court to be familiar with my dossier, I saw these materials in my dossier. So that's why it's very strange that this question has arisen today. Mr. Muzyka, don't worry, don't say that you have already submitted it. If you have submitted it, we have it. We just want to clarify some things that are unclear. Thank you. You have clarified your position.
Yes, so I will turn to the next question. In the year 2019, you purchased a flat worth of 510,000 Ukrainian hryvnias. What form of payment did you use to purchase this flat? Did you pay with cash or via bank transfer?
It was in cash, so the payments was made in cash.
Are you aware of the legal provisions that stipulate cash placements under the deeds that are subject to the notarization? So how can you explain your failure to comply with the legal provisions by making payments in cash?
I know about these legal provisions, but life is much more complex than we imagine it. And not always it happens as we wish. For example, I want to make a purchase agreement, and the other side would say that the other side doesn't want cashless operation, and I am forced to pay in cash because in other case this purchase won't be stipulated. So I took a loan in bank. I took this money from the bank account and paid in cash. I also enclosed the documents to the dossier.
The question here is just that, of course, you did not follow the rules which were applicable at that time for that kind of purchases. Thank you. I will pass the floor now to my colleague Natalia Kuznetsova, who will continue posing questions to you.
Дякую, пане Алеш.
Thank you, Mr. Alush. I would like to comment on your answer. It's true that the life is more complicated than we might imagine, but still we need to take into account that we are all legal professionals, and moreover you are a judge, and observance or non-observance of legal provisions can be regarded as a disrespect of law, but it's just my considerations. You are a doctor, you hold a PhD in legal science, and recently in November 2023 you defended your dissertation on the topic of timeshare contract in civil law. Before that, you published a number of academic articles and prepared abstracts for several academic conferences as provided for by the requirements for academic research and their defense. And the topic is quite interesting. To some extent, it's new for Ukrainian reality. I don't remember any kind of similar topics before or research into it, so it's very pleasant that it is of interest to you. And my question is the following: how did you manage to combine your studies with the work of a judge during all these years, especially taking into account that it was during the wartime and the time of the pandemic? How did you manage to do it? Well, there is already an answer in your question. It's true that the times were difficult, and due to the fact that in 2022 the full-scale invasion started, the workload for judges decreased, and during the first month of the invasion we were not considering any cases. I represent the relevant jurisdiction, and the economic activities decreased back then, and we had few cases, and it allowed me to pursue my academic activities. Actually, we listened to many judges before you, and they stated the contrary. They said that they had increased workload because the number of judges decreased. I accept your answer, but I would like to continue on this topic. Could you tell me who was your head of master thesis? It was a professor of Khmelnytsky University of Governance and Law. And who were the opponents and other academics present at the defense? Mykola Stefanchuk was an official opponent, and there were professors from National University named after Stefanik. I'm sorry, I do not remember the surnames of these professors. There was another professor from Khmelnytsky University and another one from Kyiv University. Maksym, in November 2023, during celebration probably of the defense of your dissertation, you stated that you were grateful to those who supported you in this in pursuing your academic ambitions, but you don't remember the surnames of those who helped you in this serious process of acquiring an academic degree. For me, it's strange to some extent, but okay. Do you know about the principles of academic integrity? Yes. How can you define them? What's the meaning of these principles? There is an integrity of judges, and there is academic integrity, which is about the requirements to academic activities. How do you understand it? Well, the main thing is the absence of plagiarism in works, and there were a few remarks because in some of my articles there were no references to the authors. But in the process of communication, I explained it, and there were no questions to my dissertation in this regard. Well, let's answer the question. I accept your answer that usage of the borrowed texts without any reference to the authors can be perceived as plagiarism at its non-respect of the norms of academic integrity, right? Yes. Okay, let's follow with more specific questions. I would like to invoke the abstract for the 12th All-Ukrainian Academic and Practical Conference, Traditions and Innovations of Private Law Development in Ukraine, Educational Dimension. And there you use the text of the article Timeshare as a new form of cruise business organization, dated 2012. Could you explain why don't you include the reference to this text? I answered. Please answer once again. Don't refer to your previous answers. We have some doubts. Could you please answer this question? Moreover, you were told that you have 3 minutes. Please make use of these 3 minutes to provide a specific answer. Why didn't you include a reference to the work of Yemelyanova? You used it, right? Yes. So why didn't you include the reference? It was a mistake in the abstract. At the same time, in the dissertation, in the thesis, I included a reference. In another article, Problems of Legal Regulation of the Consumer Protection under Timeshare Contracts in the Legislation of Ukraine and the EU, you used the text of the abstract by Bondarchuk and Storozhuk entitled Legal Regulation of Timeshare under the Laws of Ukraine, published in 2012. There is no reference to this paper in the list of sources or in the text. How can you explain this? Again, there is a reference in the thesis. I'm speaking about the article. You understand that article is also an academic paper. It's subject to the copyright, and it was non-respect of the copyright. It's not about your dissertation. If I'm not mistaken, there is a reference in one abstract and no reference later through the text. It's not like that, but we won't demonstrate it. And in the dissertation, there is also a copy of some text of Russian authors. I'm speaking about the collective usage of services and goods, system of timeshare as a prospective direction of development of tourism in Turkey, 2016. Do you find it acceptable to use it in 2023 when the unprovoked aggression of Russian Federation against Ukraine was already ongoing? Do you find it acceptable to use the works of Russian authors after this unprovoked aggression by our neighbors? From the point of view of scientific academic ethics, did you have any doubts as to whether it's possible? No, it's not acceptable, I think. Thank you. I would like to ask another question. You hold plots of land of 1,500 square meters and 1,000 square meters you acquired through free privatization from the state. Please explain your failure to list the plot of land of 1,000 square meters in your declaration filed for 2012 and 2013. Well, for that, we should probably go back into 2012 and 2013 and remember how the declaration was going on. It was quite formal. Could you please explain why you didn't declare it? Well, I'm trying to explain why, and the attitude to the declaration changed drastically after the electronic system of declaration was put in place with the new anti-corruption bodies. So it is probably due to this fact. And when I familiarized myself with my dossier, I also paid attention to it. Maksym, a judge, as any other citizen, should abide by the law, and a judge should be a few times more diligent, because they should be an example to others. And today you are saying us that the obligation of declaring assets was formal. If you have this obligation, you just have it, and a judge should take all possible measures to fulfill this obligation, because he's a judge and he's followed by other citizens. There is a lot of attention to him, so I don't accept this answer. I would like to follow with other questions. You were first appointed as a judge by decree of the President of Ukraine of 10th of February 2012. You started working as a judge in the Commercial Court of Rivne Oblast, meaning outside of your hometown. And 1 year later, by presidential decree of 13th of March 2013, you were transferred to the position of judge of the Commercial Court of Khmelnytsky Oblast for a 5-year term. Please explain why your declaration did not include information on your declared place of residence in Rivne at the time when you worked there as a judge. It was a mistake, obviously. A mistake. You took part in the competition for the post of judge of the Commercial Court of Cassation of the Supreme Court, and in the candidates questionnaire included in your file, in the section where you were asked to indicate your addresses of residence and legislation for the last 10 years, you indicated that from February 12, 2012 to March 2013, I lived in Rivne. Since during this period, I worked as a judge of the commercial court. Could you please explain these inconsistencies? You already said that you lived in Rivne. Where did you live in Rivne? I rented an apartment. Okay, so you had to indicate the right of use. You didn't. Okay, obviously, yes. In 2019, you received a cash loan of 500,000 hryvnias. As you informed the advisory group, the purpose of this loan was to purchase an apartment. At the same time, in your tax return of the same year, you declared cash in the amount of 300,000 Ukrainian hryvnias. How can you explain the source of this money? 300,000. Could you please repeat? Your declaration for 2019, you indicated that you received a loan of 500,000 and at the same time you had 300,000. What's the source of this money? Where did you get it? From the salary. 300,000. Yes, it's reimbursement of a charge. 300,000. For what period? What's your annual income now? Back then, I don't remember what it was back then, but now it's around 1 million hryvnias. Okay, and why would you need to get a loan of 500,000 if you have 300,000? Well, a loan is a useful financial means. I had salary back then. It was regular, and I understood that I could repay the loan. Did you invest this money? You took 500,000 with 34% of interest to pay to the bank, and you were just keeping this money just to have it somewhere in a safe. No, I bought an apartment on the next day, and I didn't have the whole sum of 500,000, so I had to take the loan. Another question. When asked by the advisory group why, as a professional judge, you applied to the Secretariat of the Verkhovna Rada of Ukraine for the post of Judge of the Constitutional Court of Ukraine, you replied as follows. My decision to apply for the position of Judge of the Constitutional Court of Ukraine under the quota of the Verkhovna Rada of Ukraine was dictated by the fact that I believe that I have almost no chance of being appointed by the Congress of Judges of Ukraine, subject to the recommendations of the AGE, but it's a completely different story. Could you please explain this story and what you meant by zero chances of being appointed by the Congress of Judges? It means that, the Congress of Judges, the chances of being appointed by the Congress of Judges are very little to be chosen from the community of judges. That was my observation. Well, as we analyze the list of those who applied for the position and were recommended by the Council of Judges, there are many colleagues from the commercial jurisdiction. We were considering the application of judges from Lviv, from Uzhhorod, from Mykolaiv. There were many people who make use of this opportunity. So it's strange to hear that you assess like that the support of your colleagues. It's easier to be in the surrounding of 450 people's deputies, then get the support from the judges. Miss Natalia, I'm sorry, I'm not saying it's the sole truth, it's my subjective impression. Yes, you said that it's another story. I just clarified why is it different. Thank you. Mr. Elish, that was all from me. If you have any further questions to the candidate, please continue. Thank you.
Yes, thank you. With respect to this last question, there is another issue we want to clarify about your possible personal or business relations with officials or representatives of Ukrainian Parliament, Verkhovna Rada. I know that we already asked you this question. Do you hear me?
Так, я вас чую.
Yes, I can hear you.
There's some problem on my side, obviously. Just a second. There was a technical problem on my side with the video. So the advisory group already asked you the question about your possible ties, relations with officials and representatives of Verkhovna Rada. And you said that there was no such, and there are no such relations. So your answer was negative. But we know that your dissertation contains an act of implementation of the dissertation research in lawmaking. And this was provided by the Committee on Legal Affairs of Verkhovna Rada. So how can you explain this, that Verkhovna Rada actually uses this in their legal documents? So do you have anyone who intervened there in this case, or there's a little bit strange, this doesn't comply, your answer with this fact. So can you explain maybe?
In my written answers to this question, I provided an answer, and I said that I had contacts and official opponent was a member of parliament, so it took place. At the same time, I am far from the idea that the implementation of my dissertation research is done. But yes, there took place an act of implementation, and the Committee on Legal Affairs and Rule of Law issued such a document, but I didn't have any personal context. Okay, then I would like to clarify the question from Mr. Alish. How you obtained this act of implementation? So physically, I understand that you wrote a dissertation. And even before the defense of your dissertation, because implementation is needed for the public defense, so how did you provide a written address, or you went to the consultants, to the secretariat, and you said that I have written such a dissertation and there is conclusion and I would like to have support from you that this dissertation is needed? So whom did you address? How did you obtain this act? My scientific advisor did it. not me. This is my answer. So you asked to do it to your scientific advisor, and she on her initiative, or she on... so your scientific advisor addressed it. And Mr. Mykola Stefanchuk, he was an opponent, but he doesn't have any signature. I'm sorry, Mr. Alesh, that I interfered in your question, but I was really very interested by this technology, how to obtain a conclusion.
Actually, it was good that you intervened. And I have another question for a candidate. So in your motivation letter, you stated that you are motivated by the opportunities for self-realization and opportunities for changes that are opened up by the introduction of completely new competitive procedure. Could you explain what motivated you, a judge with considerable experience in resolving commercial disputes, to participate in the competition for the position of a judge of the Constitutional Court? And what are these opportunities for self-realization and for change? Even if you are not an expert in constitutional law.
You know, Mr. Alesh, a year ago, I didn't even think about the fact that I could submit documents for such selection procedure, because the procedure was another one, and establishment of the AGE is a game changer that can change the rules of game and can give and provide the access to the Constitutional Court of Ukraine for ordinary judges of local courts. The requirement, a specialization in constitutional law, we don't have, so it's not mandatory for a judge of the constitutional law. So here I see opportunities and what I have already written in my motivation letter.
Thank you. I have no further questions for you. And
Чи
I
є
pass the
ще
floor back
запитання?
to our
Мене також
secretary.
немає.
Are there any other questions? Members of the AGE? I have a question. The deputy of the expert has a question. Mr. Vasyl Shakun. I hope you prepared for our interview. You studied or got acquainted with the bylaws, and I would like to ask you the main functions of a judge of the Constitutional Court of Ukraine are established in the law on the Constitutional Court. Can you say when it was adopted? I ask you to give the answer to the question of my deputy, Mr. Vasyl Shakun. Frankly speaking, you asked me about preparation, but we are talking about the check of high moral values. The level of competence in the sphere of law will be the next stage. So frankly speaking, I am not prepared. Mr. Maksym, it is strange, because you are talking like a student during the exam. Today there is examination on English, and tomorrow I will have examination on history. That's why I can't answer the history question. We are talking with you as to a candidate with a position for a position of a judge of the Constitutional Court. We would like to see your complete preparedness, so the basic legislation should be known to you, not only for the written competence test. And I think that this is a plausible question. I completely agree to you. But you see, I came here with copies of the documents. I wanted to clarify the doubts. Yeah, but if you say that your motivation is to open some new opportunities in the constitutional sphere, then I think that such basic notions should be present in the mentality of such a person. But okay, it is clear, so we will wait for your preparation and your written test. Thank you so much. There is question from Miss Maureen O'Connor.
Thank you very much. Good morning. I was interested in something that was said in your, not your answer to the last question, but previously about your motivation. And you said self-realization and for a change or a chance to change is your motivation. And then you said once the AGE, the Advisory Group of Experts, was established, that motivated you to apply because you believed, I'm putting words maybe together and I wonder if you agree, you believed in the objectivity and that judges such as yourself would receive fair consideration. Is that an accurate statement of your mindset?
Цілком вірно.
Yes, yes.
Before the AGE was established, you had no hope of applying and being successful? That's a question.
Ні.
No. You know, the practice of the last selection procedures for the judges of the Constitutional Court, testimonies about not very transparent competitions. This is my subjective point of view. Evaluating point of view, I would say.
Пані Оксана хоче запитати.
Miss Oksana. Mr. Maxim, I would like you to clarify which competition procedures you followed. So you say that you know that these selection procedures were not transparent. I don't say that they were not transparent, I say that it seemed. And which one you observed? I observed the last selection procedure. Which one? When Miss Luhiria was appointed. Are there any other questions from the experts and their deputies? If there are no questions, we are ready to wrap up. And Mr. Maxim, now you are given floor for your closing statement, up to 5 minutes. I would like to express my gratitude to the AGE members for this opportunity to take this interview. I would like to say that the international experts are really very brave and courageous, because to come to the country with the ongoing war for 2 years, it's really very brave action and activity. We have air alerts each day, there are shellings, there are terrible things, and they depress. But the fact that you are here, it merits big respect. So thank you so much, members of the AGE, and I thank you for the fact that you want to make this country better through this competition and through other selection procedures. I hope that we will manage. Maybe if not for us, but for our descendants, this country will be better. Thank you so much, Mr. Mykola Vasilyevich. The interview of the AGE with the candidate for the position of a judge to the Constitutional Court of Ukraine, Muzyka Maksym Vasilyevich, is closed.